improvements that you see in Suhakam's quasi-judiciary's power?
You see, the amendment does not say very much, except the appointment. Apart from disqualifying a number of persons, that is not our recommendation. They went at length to say who should be, who should not be, and legislated everybody out, instead of looking into the amendment which we first made to the government to give more power to Suhakam on the issue of conducting public inquiry, inspection of places of detention. Those are the issues which, and also right of Suhakam to appear in court, right for Suhakam to appear and to bring cases of violation of human rights in the court, which other countries have, Australia have. That's what we recommended. It was not looked into by the relevant agency of the government. What they are more serious is legislating everybody out and disqualifying certain categories of people out, which to me is irrelevant.
Who appoint the 3 select committees?
It's clearly by the Prime Minister.
Yeah, but he just pick and choose? I
don't know.
How does it work?
I do not know. You can ask the Chief Secretary because he is the chairman of it. I don't know.
Okay.
I'm not in the government. I'm a member by virtue of the law. Right.
But do you think there is an issue here, the fact that the government is involved in selecting the commissioners?
Well, you see, this is one of the issues with the subcommittee of the ICC raised in determining the independence of Suhakam. In this particular case, you see, the criteria of the person is spelled out by the law.
Correct, yeah.
He must be a member. That's what I said. The members of the selection committee must fulfill the condition of section 11(2). And the members must fulfill the condition of section 5.
Section 5, yes.
Right? It must be a person who has knowledge or political experience of human rights. Now, the question whether it matters the fact that the Prime Minister recommend to the young Deputy appointment, in my view, should not be an issue, because the recommendation is being made by a selecting committee consisting of 5 members. One is the Chief Secretary. One is the chairman of Suhakam, who should know what is required. 3 independent of either the government or the Suhakam.
Right.
So there is a cross section of people sitting on the selection committee to advise the Prime Minister who should be appointed. Now, it is in that context that we raise an issue with the government. We took issue with the government on the first appointment, which provide in the law to say that the Prime Minister is not bound by the advice of the
selection committee.
So we feel that if that is the case, it is an exercise in futility for the committee to sit.
There's a disclaimer to the selection committee.
In that case, why don't the Prime Minister straight away appoint he wants? Why must go through the selection committee when the law said you are not bound by the recommendation? And that is the issue raised. So we got back to the government to say, to comply with the objective and the spirit of the Paris Principle, please review this provision. And the government did. and hence this amendment. As a member of the selection committee, I would like to be advised what is the meaning of civil society in the context of this section. But if the Attorney General, whose chambers is responsible in drafting this law, has refused to give an interpretation of what he means, we have to rely on our wisdom. Well, I was advised, and this is what we have agreed, that we should invite nomination from the civil societies. And they submitted a number of person of whom they feel satisfy the condition of the law. The government too can submit names for consideration of the selection committee, for submission to the Prime Minister for his consideration, in advising the Agong to make the final appointment. So there is no secrecy.
But we don't know how many are vying for the positions. We don't know how the selection is done. We don't know what are the criteria.
No, the criteria is written here.
Yeah, but what about
the criteria is that he must have knowledge or practical experience on human rights. That is the requirement of the Paris Principle. So the criteria is spelled out clearly in the law.
Yeah, but we don't know how many people are actually vying for the positions, number one. And then
Well, the maximum of members is provided in the law, not more than 20.
People who are being nominated?
You know, to me, why you want to make it public?
Why not? It's a public office, right?
I know. You see what happened. This is a voluntary job.
Right.
He offered to serve. But in the context of Malaysian culture, if somebody is rejected, then there will be speculation of why he is not. So that would not be fair, in my view. That would not be fair to the individual. I have asked the the selection committee to seek the advice of the Attorney General. What is meant by the word civil society in the context of this law? Now, surely you are not going to invite a civil society whose function is to manage some sort of fund, or a civil old boy association of a school or college. Surely it's not intended to be so. But what can we select committee do when the Attorney General has refused to give the advice? I do not know whether he also advised the Prime Minister of the word civil society in the case of appointment of members of this committee. Because here is clearly are three other members of civil society who have knowledge. That person may have knowledge or practical experience in human rights, but he is not a member of civil society whose function, among others, is in the promotion or protection of human rights. That is key in my view.